Have the seat, Ms. Zucker.
May it please the Court, good morning. My name is Ellen Zucker, and I represent the appellant in this matter, Dr. Francisco Pardo. Before you today are 4 issues of appeal. With the permission of the Court, I will discuss the facts of the case as they relate to the appellate issues and rest on the brief with respect to the 4th appellate issue identified. I would like to turn immediately to the question of the jury instructions, and particularly to the 2 errors noted in the appeal, the error having to do with the failure of the Court to instruct on the relevance of temporal proximity where a charge of retaliation and the facts entered into evidence at trial so permit.
Why is this a failure? I mean, it seems to me you want a special rule here. Why isn't this just the rule of circumstantial evidence? There may be direct evidence of retaliation, or you may use circumstantial evidence, such as the temporal proximity of events, to reach the same conclusion. Why do we need a special instruction?
Your Honor, with respect to the law of retaliation, the Court has been clear in Bain and other places that retaliation is a specific cause of action with special elements that need guidance from the Court. It is clear from your general jurisprudence that we don't just require courts to give instruction on elements. We require them to give instruction on substantial principles that bear on material aspects of the case. That is the case here.
But in this case, the judge did instruct that they could consider circumstantial evidence of motivation and causation from all the evidence that was presented. And I take it counsel did argue the point that there was circumstantial evidence of motivation and causation here.
To be sure, Your Honor. But in this case, where the Court in Mull has been clear and said it at least 3 times, close temporal proximity between protected activity and adverse actions flowing therefrom permits in and of itself a finding of retaliation.
But doesn't that draw the judge in as an advocate in the case? If he can give that particular instruction?
I don't believe so, because what he or she is doing in that case is saying it is a permissible inference. The judge isn't commenting on the facts. The judge in this case gave instructions about what the jury may find. If they find X, they may find Y in a number of circumstances, but failed in this central method of proof in retaliation cases. That is crucial here because the temporal link was so close, and the ability as set forth in Mull to find retaliation based on that proximity is certainly not harmless.
Why don't the jury, though, make their own common sense inferences of retaliation from the timing?
They might. But as this Court has put so well over the years, retaliation requires special guidance. And this Court, in fact, has considered several times what we mean by temporal proximity and what may be found as a consequence. I would draw your attention to a case, Pfeiffer v. Salas, which is actually a 1971 Supreme Judicial Court case, on a different point, to be sure. But there the question was the weight to be given to a surgeon's admission in a medical malpractice case. And the Court said it was harmless error to give a general totality of the circumstances instruction and not specifically say that where you find an admission, you may find the facts sufficient for finding of malpractice. In other words, where specific weight can be given, specific legal weight may be given to close temporal proximity in this case, as in Pfeiffer, an instruction was required, and it can't be viewed as harmless to decline to give it because it denied Dr. Pardo a central way of proving animus and causation, as set forth very clearly by this Court.
Well, have we ever required such an instruction?
It has never come up that it has been denied. At least in my review of the case law, it has never come to the SJC as a jury question that was denied when requested and sufficiently preserved for appellate review. What has come before the Court, what has come before the Court is the question of whether, and in Mull the language was when adverse actions, harmful actions follow close on the heels of protected activity, and there really can be no dispute on the record that that occurred. In fact, the appellees in this case, although they characterize it as disputed and thin, acknowledge on pages 16 and 22 of their brief that there was evidence of temporal proximity. So an instruction should have been given.
What's the state of the law across the country on this point? Do some jurisdictions require the instruction, some jurisdictions not require it?
From what I have reviewed, Your Honor, and if you would like more on that, I would be happy to give you a supplemental brief. But from what I have reviewed, it is indeed the case that most jurisdictions talk about temporal proximity in the way that this Court has. In other words, it has not come up as a denied instruction from my review, but has come up in the context of directed verdict or
sufficiency of the evidence. Yes, because it's an inference that can be drawn from temporal proximity. But
it seems to me, Your Honor, that where we must be clear is that discrimination law, retaliation law has developed over the years. There are the elements, but there are the key principles on material issues, and that is indeed the standard of when an instruction should be given. In this case, it cannot be doubted that temporal proximity, and this Court has said temporal proximity may be a chief principle which allows the plaintiff to prove her or his case. And in circumstances such as that, as in Pfeiffer v. Salas, as in Hopkins v. Madero, cited in the brief, one must give the instruction. The error is not harmless when the facts would have permitted the inference to be drawn had the jury been aware that timing alone in this case, because it was so close, would have permitted a finding.
How can the jury have been aware of that? I mean, I take it the lawyers argued this point until they were bloodshot.
We could not argue, Your Honor, that we could not argue that that it was that if you find timing, you may find retaliation because that instruction was not before them.
Yeah, that doesn't prevent you from arguing it, does it?
We certainly argued that the facts suggested it. That we did. But we could not, we didn't have the benefit of the instruction. There were many instructions that say if you find that there was a false reason, you may infer discrimination. If you find X, you may infer Y. But we were denied this one, and this one is particularly important in the context of retaliation cases. If I may quickly address, because my time will escape me, some of the other issues before the Court. The second instruction issue before the Court was the issue of the imposition from our perspective of a reasonableness standard on what we have called in the brief the second prong of the test in retaliation law. The basic test in retaliation law, as we are all aware, is protected activity, knowledge of the employer, harmful acts, and a causal link. Under that test, in Abramian and Tate, the Court has announced that there is a good faith and reasonableness belief standard put on the protected activity and reasonable oppositional activity. There can be no doubt that under 151B, Section 4, subsection 4, that the act of filing is itself protected. The statute itself states that no harm can come to an employee for oppositional activity or because he has filed a complaint with the Massachusetts Commission of Description.
That's not in question here, is it?
Pardon?
That is not in question here.
Exactly. Thank you, Your Honor. And so the question
nobody questions that.
So the question then for the Court, it seems to me, is whether the Court erred and whether that error was harmless in stating that the jury could consider what would have been reasonable in the act of filing. It is the appellant's position that that is an error and an error that risks very serious policy harm. If we know from the Court's jurisprudence very clearly that one may have a claim of discrimination that is ultimately found unmeritorious and nonetheless succeed in a claim of retaliation.
I think this is a correct transcript of, I believe, the judge's instruction on that point, that Dr. Potter acted reasonably in response to his belief in complaining that he was being discriminated against because he was gay and or in filing a complaint with NCAD. That's the instruction that you think is.
That was the initial instruction, Your Honor. When the jury came back with a special question, and the question was this, they wanted to know on the second prong of the test, that is to say they were not focused on good faith and reasonableness in belief. But on the second prong of the test, they wanted to know what is reasonable in filing a complaint. And where that is troublesome is there is no reasonableness requirement in the filing of a complaint because the policy decision under 151B is that plaintiffs should have access to the courts, and access to the courts is through the MCAD in this circumstance.
Would the judge also continue on and say something to the effect that in order to be reasonable in the filing of the complaint, he would have had to have had a reasonable basis, an objective basis for a complaint? In other words, he would have had to have essentially had a prima facie case.
Yes, Your Honor. And that is troubling because
it has to be a prima facie case. Excuse me, a prima facie case or a non-Rule 11, in other words, a frivolous.
Well, the Court has never defined what we mean by reasonable in this circumstance. And really there are two arguments here. First of all, no reasonableness requirement should be put on the act of filing because you invite jurors sitting in a jury room to say, well, I wouldn't have filed on those facts. And that's not our standard, nor can it be if we want a robust 151B that protects people in complaining in good faith and protects their access to the courts.
But I thought the point you were making in your brief was that in her supplemental instruction, the judge told the jury that the plaintiff would have had to have had some sort of a reasonable case of discrimination as opposed to a reasonable case of retaliation.
That's exactly right, Your Honor. I think that's precisely what the judge erroneously invited the jury to impose upon the filing requirement in the retaliation claim. And I think that was surely not harmless error.
So you're suggesting that the good faith aspect of all of this is really in prong one. And once they get over prong one, have decided that the person believes in good faith that they've been discriminated against, then it literally follows that it is absolutely reasonable as a matter of law to file a complaint to that.
That's right, Your Honor. And in fact, the only place on prong two that you see any discussion in the case law, federal or state, really has to do with oppositional activity short of filing. Yeah. And if that activity is wholly disruptive to a workplace or, spray painting epithets or the like, that may not be protected because it's not reasonable oppositional activity. In Abramian, going to the Harvard Crimson was reasonable oppositional activity. So it has a wide latitude there, and it really, I think, has been understood in many ways, Your Honor, as not patently unreasonable.
That created a different ground for dismissal or termination.
That's right, Your Honor.
She did, as I understand it, and again, I'm just looking at what is in the briefs. I haven't read the jury charge as a whole, but she did say, when I say a reasonable person, I mean a reasonable person in Dr. Pardo's position in all of the circumstances that you've heard about in this case. And I suppose what is unusual, I certainly I can't think of a case where the jury comes back saying, we would like a clearly defined explanation of what actions would have been reasonable in the filing of a complaint with the MCAD. That's
an odd question.
That is the crux of the problem.
And so then the judge is faced with a very difficult problem. She did say, did she not, you cannot be terminated because you filed a complaint with the MCAD. Is that correct?
She did, but taken as a whole, she then went on to say, and reasonableness, you will determine whether you thought these actions were reasonable in the totality of the circumstances, which invites the kinds of questions that we've already discussed. And I think this Court has not had the opportunity to talk about what it means by reasonable in the first instance and to look at the impact of imposing that reasonableness requirement on the filing of a complaint, which seems to me antithetical to the basic purpose.
I take it in light of our construction and the legislature's drafting of this, that the law, she is correct. You cannot be terminated because you filed a complaint. As I understand, your concern is we don't want employers to say, but the filing of the complaint was unreasonable.
That's exactly right. Therefore, the protection does not lie. In other words, this is the same problem with the test.
Then help me with this, Ms. Zucker.
Yes.
I have, not this case, I have an employee who is not performing. And in fact, I've got an employer that is doing everything to give the employee an opportunity to to know what the expectations are and how he or she isn't performing up to expectations. And so I call them in and I put a written notice in their file and I give them a warning and so on and so forth. And I am on the cusp of terminating them. And then the employee who falls within a protected class, and by the time you cover all protected classes, I think the only people who are not protected are white males under the age of 40 who have no disability and are not a veteran, right? I mean, so we're talking about a very small group of people. Everybody else falls into a protected class. And that employee files a complaint to the MCAD. Is it your position that the employer then cannot terminate?
No. That is taken care of by the first prong and the good faith belief. In fact, these cases have been presented to the appellate courts in the Commonwealth, and where there is no shred of evidence that anything discriminatory was going on beforehand, then the complaint is not deemed in good faith. That is to say, prong one, we are not disputing the good faith requirement of the prong one of the Tate test, and that would be taken care of in the circumstance you've just suggested. If I may have 1 second to briefly draw your attention to the argument with respect to the denial of access to materials that were crafted as peer review materials.
I have one question about that. Does the request for the discovery of the peer review material have to be in connection with a suit against a specific member of the committee?
Under the strictest read of 23185N, that is the case. At the time the discovery requests were made, there were 3 named individuals who were dismissed out of the suit as part of the settlement with another institutional member. But what I would just very briefly ask.
And then was Dr. Soot a member of the peer review committee?
He was a member of some of the peer review committees from which we requested comparative data. The chief concern here, obviously, is that if there can be wholesale and widespread denials of comparative data in a disparate discipline case, plaintiffs in discrimination cases who are members of the medical profession will effectively be denied the protection of 151B, and that's the policy cases we cite. It is also consistent with IOSH, in which the court addressed peer review materials only in the context of waiver and an argument that the materials were not peer reviewed in the first instance.
I have a question as well.
Okay.
Sure.
Did you support your request for the discovery of comparative data information about other instances where patient care deficiencies were complained of? With information, about other instances where patient care deficiencies were complained about.
What we could get our hands on, Your Honor, yes, we did. And I would also like to draw the Court's attention to the record at record site 91 and 145 to 196, where sort of the procedural history of our request is laid out, as is our agreement to redact physician names and patient names so that we would not violate the heart of the privilege set forth at 111-203 to 205. That was not Dr. Pardo's intent. We have 2 very important, weighty statutory social policies, and what we suggest and would ask the Court to do is acknowledge that they must be balanced in a circumstance where the plaintiff is a member of the medical profession and otherwise is denied one of the central methods of proof in a discrimination or retaliation case.
My question is this. In I believe it was the hospital's brief, it's noted that there were 2 special questions given to the jury, but I couldn't find out how they were answered. One of the questions was the defendant's desire to retaliate against Dr. Pardo a determinative factor in any adverse employment action? Did they answer that question?
Your Honor, that was not part of our briefing, and it is now a long time ago, and I will actually ask submit it to that. I'll
ask the other side. I'm sure they know the answer since they put it in their brief.
The answer must be yes. I mean, they must have answered the question.
I believe they must have, but I'm not certain enough as I sit here right now to be able to answer.
Okay. I mean, it seems to me if both answers were no, then this case is over. There's no causation. They found no causation or no relationship. So that's what I asked. Well,
it may or may not be over, Your Honor, if the temporal proximity and the good faith and reasonable response to filing is a threshold issue in a retaliation claim.
Okay.
So you don't get there.
Thank you, Ms. Zucker.
Thank you, Your Honor.
Mr. Reardon?
Thank you.
May it please the Court, my name is Frank Reardon, and I appear on behalf of the General Hospital Corporation doing business as the Massachusetts General Hospital. This case had a somewhat long history of
How did they answer that question? Do you
I can
remember?
tell you, actually, the jury questions were for Your Honor, and they're on page 2628 and 2629 of the record appendix. The first question was, has the plaintiff established by a preponderance of the evidence that Mass General Hospital acted with discriminatory intent, motive, or state of mind against Dr. Pardo on the basis of his sexual orientation when it took any adverse employment action? But there was a space for yes or no, and they answered no to that question. And then it said, if you answered no to question 1, go to question 3 on the jury slip. And then it said, if you answered yes to question 1, go to question 2. Question 2 is set forth at 2628. And then they skipped that because they answered no to the first. Question 3 is, has Dr. Pardo established by a preponderance of the evidence that the defendants desired to retaliate against him for engaging in a protected activity? And the answer to that was no. And then question 4 was the damages question.
So I thought, was the defendant's desire to retaliate a determinative factor? Or was that question?
That question was answered no. Question 4 was the defendant's desire to retaliate against Dr. Pardo a determinative factor in any adverse employment action? I do not believe, my best recollection, Your Honor, is that I do not believe they reached question 4, because if you answered no to question 3, you didn't have to
do it.
reach
So
question 4.
Ms. Zucker is correct in this respect, that if there is a ruling that the instructions were in error, then, in fact, the case is not over because they answered no. I'm just, hypothetically, no based on 2 erroneous jury instructions, correct? I'm not asking you to agree that the instructions are erroneous, but if the instructions are erroneous, then the answer to question 3 can't stand, correct?
I
don't know whether I've got the right answer, the right question.
Well, there are 2. I really don't agree with that analysis, Your Honor, but respectfully.
Yeah.
One of the things, actually, one of the points I was going to make on this is that we agreed on the jury slip. That is a jury slip that went with agreement with the judge. We were fortunate in this case in that Judge Gershengorn agreed to sit specially on this case, which doesn't happen very frequently at the Superior Court level. She sat specially on this case for almost 2 years. So when the case came to trial, she was very, very familiar with the issues before the court. And the discovery issue, she heard all of the discovery issues, all of the peer review issues. I understand that the record appendix in this case is 6 volumes, but there is a great deal of information contained in that record appendix because it shows Judge Gershengorn's familiarity with this case and with the underlying issues in the case.
Can we talk a little bit about the peer review statute?
Yes.
It seems to me there's 2 issues with regard to that. The first one is whether it actually would apply to this kind of case, because the bad faith exception seems to talk in terms of suits brought against the members of the committee, and by the time this went to the jury, there were no individual doctors still involved in this suit. Am I correct on that?
Yes, but I would like to respond to that. There were no individual doctors left, but the trial court allowed the transcript and the documents from the hearing to be used at the time of the trial in the case as if the 85N exception applied to the case. In fact, at one point in the transcript, she makes the finding that this may not even be subject to peer review. This hearing may not have been subject to peer review. My understanding of the record is that, and I was there, I tried the case. So when the...
So what are you saying, that the plaintiff got a more favorable treatment than the statute permits him to have?
I certainly felt that way at the time of trial, Your Honor.
All right.
I'm not here on appeal. But I certainly
You're talking about under Section 85?
Right.
Under Section, yes. But actually what the judge...
But what about under 203, 204? I mean, first of all, it seems to me that that's where the conflict between the 2 public policies comes, correct?
Yes. The judge actually found that this did not qualify as a peer review hearing in the sense that the transcripts and documentary evidence from that hearing should be kept out of the jury's consideration. So at the time of trial, actually plaintiffs spent a considerable amount of time cross-examining witnesses, such as Dr. Soot, on things that he had testified at the time in the peer review, what I considered to be a peer review hearing, or the staff privileges hearing. The peer review issue came up in more expansive requests of the plaintiff.
Or comparative data. And
That were extremely broad-based. And this is where the record is somewhat helpful.
Well, that's the second issue on which we got sort of a dilemma. On the one hand, in any disparate treatment case, a plaintiff plaintiff doctor could complain of discriminatory conduct in the peer review of treatment and want to look at others, and that would completely blow the privilege out of the water. On the other hand, if he can get to the jury, as this doctor did, because there was some actual evidence of discrimination, he would be denied, a similar plaintiff would be denied some very important information, all of which could be protected by redaction and in-camera review by a judge. And I guess the federal courts that have looked at this have all held you can get at this stuff. So where do you, I know where you come down, but how do you get us out of this problem?
Trying to be candid. I think the federal court, first of all, it really is distinguishable. In every case that was cited, the federal courts have said, we're not bound by state statute, we're bound by federal common law, and we will consider state peer review statutes if, in fact, we find them to be consistent.
But, Mr. Reardon, my problem is, if there's a finding, if there's a legal conclusion that these were not medical peer review, and when you said what I take to be peer review, i.e. staff privileges, that's not what the peer review statute is designed to do, correct? So granting somebody staff privileges is not normally subject to, would not normally come within, the ambit of 203. When the peer review, the public policy purpose behind peer review isn't whether or not I'm going to let a doctor have staff privileges. There are lots of reasons why you might grant or deny a doctor staff privileges, correct?
Yes.
So don't we have to first make a determination whether or not the records sought were peer review, even if they were in certain circumstances, the compelling, counter public policy may warrant their disclosure subject to appropriate protective orders. But if they're not, why does the doctor have any difference? Why is that different than any other employer who would have to come forward, again, could well be subject to appropriate protective orders of comparative data?
I do believe that in the Carr case and in other cases,
Right.
this court has not that narrowly defined what is and is not peer review in the credentialing process at a hospital, nor in the hearing process for removal of staff privileges at a hospital.
I thought we were looking at his request to get data of other, what is, everyone agrees, is peer review stuff of other doctors who had their records and files and treatment examined under peer review statutes when that treatment called into question its medical acceptability. Didn't he want to look at that stuff? Or did he not want to look at that stuff?
The requests were more broad-based than that. The requests that are in the transcript were very broad-based, going back 10 years.
But clearly covering the point is clearly covering peer review
information, yes.
Yeah.
And
Not just staff privilege
what the trial
information.
courts, that's right, I'm sorry. What the trial court has been, most trial courts actually have been refrained from doing, is invading the evaluation process.
Yeah, but what I want to know about here, is there agreement that I can find somewhere in the record that everybody understood that these were peer review materials? Let me tell you why. There are lots of circumstances in which employers have said it would be immensely harmful to our business purposes to have to disclose this information. the classic case was tenure at universities, which had always historically been absolutely closed. You solicit very frank comments. That's a sort of similar kind of thing. And the Supreme Court, 9-0, University of Pennsylvania, what's it now, 25 years ago, said, guess what, the anti-discrimination laws are more important. Now, if it is absolutely clear that everything that this plaintiff was seeking was in fact covered by
Peer review,
as it has been defined somewhat narrowly, because I think the legislature knew exactly what they were doing. They had a particular public purpose in mind. I'm not sure that we have resolved that issue, but at minimum I have to know whether or not I'm under the narrowly defined peer review statute.
The documents that were being sought here would be under the umbrella of the peer review statute, and I do believe that is the way Judge Gershengorn interpreted the documents that she did not permit to be disclosed during the course of discovery. Yes.
Okay. So there was no claim by the plaintiff, Judge, whatever you're deciding about the documents that are covered under peer review documents, there are some other category of documents which are not even peer reviewed.
Just so that the Court understands, there were hundreds, perhaps thousands of pages of documents produced in response that did not fall under peer review. It was understood between the parties, I believe, that the documents that were not allowed to be produced or not ordered to be produced by Judge Gershengorn were peer review documents.
And if we look at the peer review statute and we look at the document request, is it clear that there would be the documents that were denied to the plaintiff, it's clear that they do fall under the peer. I mean, they may have waived their claim if they didn't preserve the claim that these were not peer-review documents.
203 or 204. I think it is clear from the record that they do fall under those sections, Your Honor.
Okay.
Was the memo that Dr. Hartford submitted about the quality of the plaintiff's teaching and patient care activities written at the request of Dr. Soot? Did Dr. Soot request that memo?
Dr. Pardo spoke with Dr. Soot, and this is referenced in the testimony, that if he was having complaints from people, he would ask them to solicit information from people in writing so that he could see it. Dr. Soot testified, and I don't think there's a controversy about that conversation. Dr. Soot testified, well, then I'll do that if you really want me to. He then went to a number of individuals. So in the context of that investigation of complaints about Dr. Pardo, he went to Dr. Hartford and asked him to put the complaints that he had previously brought to him in a memo in writing to him. And that's what he had. And in fact, on that issue, on the legitimate business purpose aspect of trying to prove these cases and trying to withstand challenges to employment decisions, it has been good practice to ask people who make what would be tantamount to hearsay or verbal statements about other people, to ask them if they feel so strongly about it that they would put it in writing, that they actually would put those claims down, and that the supervisor or the boss could rely upon that in reviewing with the individual what the claims were about them.
And also, you make this, the plaintiff made the statement that there was no record support for your statement that the plaintiff had concerns about his treatment dating back to 1993.
I believe that there was testimony within both the deposition transcripts and within the transcript before the court that he did have concerns. What I think the distinction might there be, Your Honor, is that they were not articulated complaints or concerns until later. But he did, in his testimony, I believe, say that he had concerns as far back as 1993 about the workplace. One of the most compelling pieces of information, of testimony that we were able to put on here, actually, we actually had testimony from, and it was quite a long trial, but from two witnesses, one who was a professional in the department who is gay and was openly gay and was recruited by Dr. Soot knowing that, and another by an administrative staff person who was openly gay, both of whom testified at trial that they didn't feel that there was an air of discrimination in the department against them because of their sexual orientation, nor that they had issues. My client takes strong exception to any type of discrimination in the workplace. This trial and this hearing the internal hearing took months to conduct. Literally, the staff review hearing here took literally months to conduct. The Judge Gershengorn had hundreds of hours of review of this case. On the issue of circumstantial evidence, she actually did instruct the jury quite extensively on circumstantial evidence and felt that that fell under the rubric that the temporal relationship was sufficiently covered by that and without pulling it out from under that. On the other issue of the filing of the MCAD complaint, I would direct the court to Record Appendix page 2642. The judge at that point is struggling with the issue of both the temporal relationship and the second issue in this case when she talks about then the reasonableness of the filing. And what she says there, and it really elucidates her thinking on the point at 2642, that it could be that it was the jury could infer that it was reasonable based on his own feelings, question number one. Or it could be found, and she goes on to articulate this, there was a case Montero, which is a First Circuit case, which was cited in the brief. Or it could be found that it was taken as a preemptive strike to bind the hands of the employer from taking any further action in light of the fact that he knew further action might be coming, because once the complaint was filed, it would be retaliation per se if they were to take any further action. I would just suggest to the court in closing that retaliation is a very difficult issue now for employers to deal with in the workplace.
Thank you.
Yes,
Mr. Wade, may I just ask you one question? Is this, the appendix that I have, is this an agreed-upon joint appendix? In any case,
yes.
Just to counsel, I don't believe that, at least in Volume 1, we have a copy of the docket. I know we have a copy of the...
I'll have that.
I need a copy of the docket. I think the rules require that. Thank you.
The other thing that's not in there, and the reason I referred to the jury questions, the jury slip is not in the record appendix.
Well, counsel, particularly in civil cases, if you don't give us what you want to rely on,
yes,
it's very difficult for us to have to give these out. So if there's no objection, let's get that jury slip as well.
I don't think yes.
Okay. Thank you.
Thank you very much, Your Honor.